Hi, I'm Karl Konrad, and it's time to take a look at the latest news in Australian immigration for September. There are new partner visa laws coming your way, and these are rumoured to come into effect sometime in mid to late November. These laws will effectively limit the lodgement of partner visa applications. The first change is that you will be required to have an approval of sponsorship before an applicant can apply for their partner visa. Currently, you can lodge a sponsorship application and a partner visa application at the same time. So far, it is expected that sponsorship pre-approval requirements will be limited to the sponsor passing certain character criteria. There are also changes to the requirements for the visa applicant. A new English test requirement will be introduced, with applicants required to demonstrate functional English skill. This can be an overall score of the IELTS test of 4.5. Evidence of functional English, however, does not need to be provided in the first stage of the partner visa application, but later when the permanent residency visa is being assessed in the second stage. Applicants unable to demonstrate functional English will need to provide documentation showing that they have made a reasonable effort to obtain functional English through sitting at least 500 hours of English classes. If you're planning to lodge a partner visa application in the coming months, then it's best and recommended that you do so before these new laws come into place. There are now only 2 states open for offshore applicants and generally for the 491 visa applicants only. They are Tasmania and South Australia. South Australia is open to offshore applicants for limited occupations as indicated on their occupation list. Tasmania is open for those on its Tasmanian Skilled Occupation List and only for the 491 visa. Regarding the Northern Territory, they are still closed despite reports of being open. As it states on their website, offshore applications remain closed while national border restrictions stay in place. Once the borders reopen soon, it is expected that many states will fully open up, but don't expect much for a while from the hermit states of Queensland and Western Australia. Despite official announcements, the Queensland government is yet to provide an update on its nomination requirements for the 190 visa and the 491 visa. In August, it was stated on the Queensland government's website that the requirements would be out in early September. And then in September, they changed their statement, pushing the release to sometime in September. Now September has ended and they have still yet to open. The delay is generating some anxiety for 491 visa applicants under the small business owner category who are waiting to apply, having completed 6 months of running a small business in Queensland. September invitation rounds have occurred in New South Wales, the ACT and Victoria. Candidates selected for New South Wales 190 visa nominations have generally been for professionals holding a point test score of 95 and above. For Victoria, candidates are chosen based on being able to demonstrate that they are highly talented and would contribute greatly to Victoria. These candidates are cherry-picked based upon their submissions and their points test score does not need to be high. For the rest, Victoria uses the point score to decide. In September, these candidates were at 90 to 95 points for the 190 visa. According to the ACT, which uses the Canberra matrix to screen its candidates, it is noticeable that a higher score has been required for most occupations across the 190 and 491 visa. This is a good indicator that the competition for the ACT has increased. It is still early in the migration program, however, and it is possible the score needed will lower between May to July next year towards the end of the program, and the migration program follows the Australian financial year. The Victoria and New South Wales governments have released their basic nomination requirements for the Business Innovation and Investment 188 visa. This migration program year, the requirements have become much harder compared to previous years. Notably, for New South Wales, you will need a combined net and business assets of 1.75 million and a business turnover in 2 of the last 4 recent financial years of 1.2 million. New South Wales has also added the requirement of a bachelor degree level qualification. However, 3 years of business experience in New South Wales target sector or 5 years of business experience in a non-target sector can substitute the bachelor qualification. In Victoria, the requirements are even tougher. In addition to a good track record of running a successful business, you must also have STEM qualifications or a MBA or relevant business history in a eligible target sector. You will also need to provide a business proposal demonstrating innovation and job creation within Victoria. Fortunately, the job creation requirement is only to eligible full-time employees. Last week, the Immigration Minister released a statement saying that in the last migration program year, a record 72,000 partner visas were granted. That is the highest number in the last 25 years. A total of 160,000 grants were realised, which is an increase over the previous year of 140,000. He said that the visa processing focused on onshore applicants in critical sectors and occupations, with 71.2% of applicants finalised in the skills stream and 64.8% of family places were delivered to applicants onshore. This has been the top immigration news for September. Subscribe to our channel to never miss important updates and to learn more about how to get a visa for Australia. If you need help for applying then with your visa and mapping out your course to permanent residency, reach out to our specialist for tailored advice. Consultation fees apply and you can book an appointment at australiavisa.com. Make sure to follow us on Facebook as well to get the full range of updates. As always, take care out there and I'll see you next time. So bye for now.